that would be an illegality. It's like the High Court telling the Chief Magistrate to handle a murder case. It's an illegality, ab initio. I would wish to draw court's attention to the case of Uganda Revenue Authority. Uganda Revenue Authority versus Rabo Enterprises Limited, Supreme Court Civil Appeal number 12 of 2004, where the Honorable Justice Lillian Tibatemwa Echirikubinza stated that where a court held, oh, I beg your pardon, where the court held that registrars cannot exercise jurisdiction beyond their express legal mandates. Your Honor, I don't see you writing. I read it's captured even in your report.
Instantly, I was asked you to click on the microphone. It's not out of the book. It's for a reason that you are being captured verbatim.
Most obliged. I hope this excerpt is not expanded. But it says, the court said, where the court held that registrars cannot exercise jurisdiction beyond their express legal mandate. The effect of this decision, and my Lord, Your Honor, I'll furnish court with a copy of the decision. At the rise of court. It's there online. Your Honor, it's online. They can check it out. It's online. Your Honor, the IT specialist can confirm that there is internet in court right now. Most obliged. The judgment emphasized that any action taken by a registrar outside his or her bounds is null and void ab initio. And I already stated that not even an order of court can confer delegated powers. To that note, Your Honor, I appreciate your expressed desire to hear the sureties. I really appreciate. This matter has been adjourned severally, like counsel said. But in the interest of maintaining the integrity and legitimacy of these proceedings, it is in order that the law be followed.
I
beg your pardon?
I appreciate the express desire. That I have the express desire by the registrar. I'm not asking other instruction, but it's my desire.
Your Honor, if you have, you can borrow me a better word.
The court.
How did you rephrase? I'm trying to think. But I appreciate the express. Your availability. I could use the word availability.
It's the court.
You know, I wish to distinguish the court, the judge, and the court, the registrar, because that's now where the gist of the discussion is. I say this respectfully, Your Honor. I'm not trying to. I'm just concluding my prayers so that we get into. Yes, like I said, I appreciate the express availability of you, the Honorable Registrar, to receive the particulars of the sureties in this matter. However, in the interest of maintaining the integrity of these proceedings and legitimacy of the application that has been filed by the applicant, it is only in the interest of justice that either the matter is adjourned until the availability of the judge to entertain it, or recourse can be sought from the head of the division or any supervisor to have this matter reallocated and heard by any judicial officer who is available. Otherwise, we shall suffer a fate, the applicant will suffer a fate where several applications will arise to be determined, pending even the determination of his home bail application in regard to the legitimacy of the proceedings. It is the applicant that will suffer. I really want this matter disposed of as quickly as necessary, but in the right way. In the right way. I so pray, Your Honor. She associates with my submission. Maybe the clerk can first reiterate what I was saying before counsel starts to the applicant.
Senior State Attorney. Firstly, to note, Your Worship, is that the court is not making a determination in this matter. The court is not sitting to determine the matter. Those are very key, important issues to note. The court has specifically stated that it is here to receive on the sureties by identification as directed by the trial judge. Your Worship, I want the court to note trial judge. The trial judge is every known in this matter. My learned friend has considered that the trial judge gave directives. Unfortunately, is not here either on health grounds or other grounds, and has issued a directive to that. It's unfortunate, it's baffling that my grand senior state attorney, who has practiced before this court, cannot appreciate the administrative nature of this court. Your Worship, the grand senior state attorney has stated that section 15 of the TIA enjoins the court to hear bail applications in the High Court by a judge. We do agree that is the position. However, Your Worship, you're not sitting in this court to hear bail application. In fact, the court has near as possible, have always adopted the procedure under section 14 2C of the Jurisdictional Act in as far as section 14 2C of the Jurisdictional Act. In circumstances where there is no proper procedure and the court is enjoined to promote good. That section, Your Worship, is to the effect that where there are no express law or rule is applicable to any matter in issue before the High Court, in conformity with the principles of justice, equity, and good conscience, the court is enjoined to adopt the procedure that aims at promoting equity and good conscience. Your Worship, the directive by the land trial judge is in conformity with this particular provision. And indeed, Your Worship, it has been a practice of this court where the court, under that particular provision of the law, directs the registrars to either identify or receive passports in case their application has been concluded, or enforce the directives of the land trial judge. It is in conformity with that particular provision. Your Worship, it is our fortified submission that you ably in charge of the directive of the land trial judge. You're not sitting as a court here at their application. And indeed, as the land statute has stated, section 43, equally enjoins this court to give such directives in order to achieve the ends of justice. Your Worship, the land statute has relied on the case of Bravo Enterprises to claim that this is a matter where you're sitting as a registrar to hear the matter. We disagree first and foremost. In the Bravo Enterprises case, Your Worship, the registrar entertained certain matters when he did not have jurisdiction. He had determined, and the Supreme Court said no, you do not have such jurisdiction. This is not a matter where the court is hearing. This is not the matter where the court is saying the sureties are substantial. That is not there. The submission of my land state attorney should have arisen at the time of an appeal, in case you want to appeal, that you entertain. Your Worship, it is on that ground that we invite you to proceed and entertain the receipt of the sureties. My land colleague, Mr. Sekou, has something to say.
May it please Your Worship, I would like to emphasize section 43(2) and read it in verbatim, that talks about officers of court, and it states as follows.
Section
43(2) of the Jurisdictional Act. 43. That's subject to Article 133 of the Constitution. The officers of courts of judicature shall perform such duties as may be assigned to them under the rules of court, and shall be subject to general direction and supervision. And also 43(1) states that there shall be such officers of courts of judicature as may be necessary in performance of any such special duties in connection with the business of courts of judicature. And such officers may include the chief registrar, registrars, deputy, etc. Your Worship, when you are here, states can also attest. Just a second.
I just want to put clarity. The provision is being done to ensure that we exceed provision. Because the 43 is reading is not the 43 I see in the 7th revised edition. I just want to maybe clarify that we seem to read different laws.
It's clear here that where in any case no procedure is laid down for High Court by any written law or by practice. Section 43 of the last it is. And in any case, Your Worship, my learned colleague clearly stated that this court has adopted a practice in applications, and would like to say that you're seated here as court, not in your own capacity or from your own function. And you stated that immediately you had entered. Your Worship, you clearly stated that you're here to identify. In any case, we already made submissions that you clearly stated were already a record of court. And they associate themselves to those submissions because they have theirs in reply. Meaning, Your Worship, that even a mere giving of date, he will object because you're not, in his opinion, the trial judge. And he would say that that would be a faulty proceeding by his own assertion and submission. In our opinion, Your Worship, you're here in the rightful capacity, and we invite you to perform your duty as assigned to you as court. Most obliged.
Your Worship, just one thing, because the United States Attorney relying on government enterprises versus the other person, of course, that was equally civil case. But this court equally is enjoined under Order 21 of the Civil Procedure Rules to entertain interrogatory application. Your Worship, we are not saying you entertain an interrogatory application, but this is an interrogatory application that you are equally mandated under Order 51 of the Civil Procedure Rules to entertain. Because this is a very application arising out of the main case. So, Your Honor,
I don't want to
most of them. So, Your Honor, it is our submission that just like how the court gives directives to you to adjourn matters, these directives are in sync to seal the surety that the court has. The trial judge has not divested himself of the powers to entertain and determine the application for bail. That one is not in order. Secondly, the trial judge has not directed you to determine the substantiality of the witness of the sureties. The trial judge's directives are very clear. Receive the sureties. And Your Honor, that is a noble duty that everybody should be in position to appreciate. First and foremost, the documents are already on record. In regards to the sureties, the now state attorney replied to those documents. What is here is specifically to identify the sureties that the court has never had occasion to look at.
Can we have a
Your Worship, if you so wishes, but I don't think that can.
Most obliged, Your Honor. I begin with the submission that this Honorable Court under Order 51 of the Civil Procedure Act has powers to entertain this application. Your Honor, it was on record. I pray to make
and I said
response.
don't play the board. It's not going to play the board.
Your Honor, this matter has been captured on the record.
Yes, it has been captured. It's very important.
Your Honor, I don't mind that you don't record it,
Okay.
but I pray that I still bring it up. Most obliged. My brothers submitted that this Honorable Court by Order 51 of the Civil Procedure Act has the powers to entertain this application.
But that's not what he said, but he said interlocutor application, and he was referring that this is an interlocutor application.
My Lord, it's actually the same argument.
It is overruled that this court cannot entertain interlocutor application in more times. Proceed. So I am with your application.
And on that overruling, on that ruling, this is an interlocutory application. The bail application is an interlocutory application. And as court has rightly ruled that it does not have power to entertain, sure, it does not, and I agree with it. My brother has continued to submit that the court, as it sits now, is merely hearing the application, not determining the application.
That's what court is always.
Your Honor,
The court is receiving, Your Honor.
the record is clear. We can always get a certified copy later, and we shall know what each person said. So my brother has argued that this court is merely hearing, not determining. And he further stated that the court is merely hearing from the sureties who are already on record. How can court determine if in the first place there was no hearing? You know, just the thought of it, it doesn't make any sense. By this court as it's sitting, receiving the particulars of the sureties in the record, that in itself amounts to hearing. Whether it determines the application or not is something else. And that is the integrity of this application that we seek to have maintained. The entire process of it. By hearing the sureties, getting their name, getting their residence, getting their phone number, getting their national ID details, that in itself is tainting the application in its entirety. And we want to arrest that abuse. And there is no doubt, once an illegality is brought to the attention of court, court must not close its eyes to it. My senior brother, the Honorable Sereko, said that I had said, and I wrote it verbatim, that I had said that this court has in the past adopted the practice in applications. I did not make that submissions, far from it. And there is no practice I brought to the attention of court that has been adopted before. You know that there is a very big difference between a registrar appearing in a matter such as this and adjourning, then appearing in a matter as this and receiving particulars of sureties. When a registrar sits and adjourns a matter, the registrar is not hearing the matter. But when he goes ahead to entertain and get information that informs the determination of the application, that is a hearing of the matter. Which cannot be tolerated by this honorable court. A section was read, section 14(2)(c), and I would first want to read it verbatim and I make an explanation thereafter. So section 14(2) says, subject to the Constitution and this Act, the jurisdiction of the High Court shall be exercised A, in conformity with written law, including any other law in force. Then when we jump to C, where no express law or rule is applicable in any matter in issue before the High Court, in conformity with the principles of justice, equity, and good conscience. No express law or rule is applicable in a matter in issue before the High Court. When the law says before the High Court, it is talking about before a judicial officer entertaining, lawfully authorized to entertain the matter. The High Court is not seated here. It's not. We cannot say these proceedings are proceedings of the High Court. They aren't, as far as this provision is concerned. So this refers to the High Court sitting. And it says that the principles of justice, equity, and good conscience. What does justice require? What does equity require? What does good conscience require in the instant case? What does it require? What does justice require? The man is rotting in prison, he needs to come out. But we are not going to illegitimize his application. He needs to come out. And I'm okay with him coming out, but in a proper way. So what does justice require? What does equity require? What does good conscience require? In a division like this, where there are other judicial officers, what is too hard with another judicial officer today hearing this matter, one authorized by law? Today, that would be justice, that would be equity, that would be good conscience. What is too hard with that? Let Mwizera have his day before a judge and have his application determined. No, my Lord, counsel, you are not going to divert me. I am responding to section. I'm responding to section 14(2)(c), and that is what was raised. My brother, please do not distract me. For your record, I cannot be distracted. For your record. Most obliged. And I request my brother respect.
When you raise it up, take it. And
That is. So my brother, first, it's my day. What does the principles of justice require? What do the principles of equity require? What do the principles of good conscience require? Under the instant case, where even the registrar wants to receive particulars of sureties, but cannot go further to hear anything further than that. What is justice? When we are going to adjourn the matter, then when a person who can entertain it comes and you see, think about it. Your Honor, it is my duty as a Minister of Justice to make sure that any illegality, whether it works on my behalf or against my behalf, it is my duty to make sure that it is arrested at the earliest opportune time. And I submit that, Your Honor, the best that this court right now can do is either adjourn this matter till a judicial officer that is authorized appears to handle, or Your Honor, seek supervisory intervention to have this matter reallocated before any other judge today, and we have this matter disposed of today. I retaliate my higher prayers.
number and the submission of both sides. I not discourage the concerns of the prosecution. I think by senior state attorney a bit more. Above all, I have looked at the law as cited by all counsel in this matter. I got instructions immediately to identify the sureties whom the applicant proposed to court from the prior year. This is the administrative function that registrars are not good. Identifying sureties is to compare what is on record already as sureties with the actual persons in court. This practice has been long in place. It's not an invention by the judge in this matter. To require a registrar to conduct the identification of sureties. It's one such master that notifies registrars that notified me was done. This is done not only in application for bail, but also in application in administration process, where applicants are seeking for letters of administration. Neither is the registrar goes with authority to grant letters of administration or to hear such an application, just as in bail application. Yet in all instances, the trial judges have often authorized registrars to conduct identification. In my view, the identification of sureties does not amount to a hearing of an application. Because the sureties have already been identified in the pleadings and in the submissions. There is no illegality that is being condoned, which is clear by the prosecution that responded to this application. It is the practice that the court had in accordance with section 43 to the KIA for registrars conduct identification. Now, the role of this court here aims at satisfying court that indeed what was recorded by court under the pleadings has been also motion and the applicant, and the submissions is what the applicant is presenting. With all the above said, this court proceeds to have identification of sureties in this application conducted. I saw order.
Most obliged, Your Honor. Your Honor, I just needed to go on record that I intend to challenge the ruling of this honorable court. I just want that to be Most obliged.
That's the order.
Yes, that's the order. Is the facility, the facility, and the paragraph each will be updated. Your Honor, all the documents in respect of those fields that are submitted to court.
Are you watching the
No. What they're telling you not to use the microphone. I also not going to do that.
My Lord, I request that council first withdraws comments regarding
Withdrawal.
also.
It was okay. Your Honor, the documents for Mr. Pasalisu were submitted. Known as the court is limited to identification. We pray that the court identifies Mr. Pasalisu and takes him as a child. So, maybe just to schedule a national ID for the applicant in the court. You'll see later. We end up in Council 1 to the record.
Bill number is CM709 and 103 M4FC. The names of Pastor Joshua
That is the position motion.
Council, but this side my pastor.
Mukasa. Mukasa. Tutakaba kugenda nga koti nao gamba ntivaawo kumoja kumawo nokwateka microphone yako. So kati gwamaze nemabega wasemba naye gatemuvaawo kulyamala nemagao
The second surety before I use Mr. Family Aristo. The documents invested to Mr. Family Aristo were submitted on record. The copy of this international ID offices of comparison and identification.
Submitted in original.
In the photocopy, that's the
Even the rest of the documents are photocopies.
yes, sir.
The bill number is CM710-321-04-587L. So one in Aristo.
This is one. That is what the record says.
Aristo, you have a phone?
We have
What numbers?
0774 97 18 90.
Any other?
0753 186 720. A permanent resident of Matilda, or Turkey, and a provides here on there.
Where's my
Matilda on Congo Road, just 12, around 12 kilometers from Kampala.
The third street is Mr. Mwizera Akomyewo. The documents in relation to Mr. Mwizera Akomyewo were submitted on accused and also to file of the court. Copy of his international ID. Purposes of compiling the application.
Sealed by Koti.
That is the jurisdictional document.
How do you relate with the abstract? What do you think? What colors do you read? I will read the form.
Yes,
So, you see one?
yes, you are.
Which one is that?
Which one?
Surety is the Imam Wanga Siraj, the spiritual leader of the Rush for the documents in respect of Imam Wanga Siraj. We are submitting on the record. We also have national ID Imam Wanga Siraj.
What line?
14.
Rewind. Again.
075 52 that the telephone number and others, the telephone number for this Hajji is 0752 52 82 then 14. The number is very recorded.
Let me hear from Mwizera. Dan. Your responsibility is one. And go back.
Kuliriza olusibe okutuula mu kooti wemwagalira tatalaganya okumuziza otatagalia obujulizi
That only one. Where is the Dan?
yes. What phone number is 0277 077 another one is 004
The first one. Not in capture.
Yes.
The first
was the first one?
0,777.
0,777.
07. 347 again.
347. 047. It's okay.
Any other one?
No, there's a.
Let me come. One person. This one person. What are the responsibilities of the
Obuvunaanyizibwa bw'omuntu eyeemeddwa obuvuga buliwo okwinjiza obusigo obujja mu kkooti.
That one has not been said.
Ekyo bakyogedde kati byereeta ansa eyimuka singa basobodde kujja ekitegeeza polisi abafuuzi kesi that is unable to come and attend is a duty bound to come and inform court why he has not been followed. So
What is ready to happen is the doctor now
Hajji, tubasonga muki ekikutuukako singa oli aba talabise mu kkooti taze mu kkooti balina okujja mu kkooti ekumi embala lwakwaba ensonga
found that he has disappeared and
kati ebiri mbagala obulansa singa kizu kijja nti abuze talabika oba waali naye akujemedde agenda okujja mu kkooti Seka, ekyo kkooti ekyatadde nnyo obuvunaanyizibwako kati nga nti omuntu yenna wabanga ateekeddwa okukola ekiro ekyagwanidde okukola n'atakikola bwa muvunaanyizibwako oteekwa omukwata weebale lwansanti okufuula.
But you are going to enter into an argument with court that the way that you cannot turn up, you are going to pay money.
Kati kkooti keyagala okutegeeza si gokana n'abalala nti waliwo ensimbi ezijja okuteekebwawo eyimiddwa omuntu ono singa kiba kizisobozezza kkooti nti kyegenda okukola ensimbi ezo singa omuntu oli abula n'atalabika tewali kulonzalonza ensimbi ezo bisasula ekibazingirawo mwenna nti bwe guba nga buli mukisa nti omuntu oyo kkooti singa tetunaba kutegeera olwalambibwa kkooti naye singa kkooti eba muwategeero bavunaanyizibwa mwe mwenna okuba nti mumukaka kkooti ennaku zebeeteesengawo okulabika mu kkooti wa ekyo kikola.
upon identification of submission with one-page submission. And if an objection, an objection to the sureties, please, after this identification, any further objections or submissions, one-page submissions, can go over. More of the
No, Your Honor, actually, I intend to do some cross-examination of the applicant. So I cannot put in submissions before I cross-examine.
So you will not learn cross-examination?
Yeah, sure. I'll teach counsel that if you time.
It is not at this time that you should make that application. And so that in the same time he has doubted jurisdiction.
No, at any stage of the hearing. So he's asking, he wants cross-examine the applicant. So all those are the matters for the hearing to determine. And so
So that's not, I cannot put in any submissions now until that process is done.
So you are asking for it to cross-examine.
It's not actually a leave, it's a right that I have, yes. It's not a leave. Yeah. It's a right that I have. On the entirety of his affidavit, entirety. And Yoshi, just to add a prayer, I pray that the record of court in respect to today's proceedings are transcribed and furnished to the prosecution, because we tend to challenge the ruling and entire legality of the proceedings.
Applicants on the application.
Your Honor, first and foremost, your jurisdiction has been doubted, right? So the minor colleague is just notified that you can undertake do this process. So in as regards, I'm going for that. I'm just re-emphasizing the fact that now the land is near set up, and I believe that this process can be undertaken by the jurisdiction. For his cross-examination, but that should have been indicated at the beginning of the matter before the judge issued the directions. But be that as it may, Your Worship, the objections were made these submissions. In respect of the applicant, and even on the surety.
Matter plan to visit.
Your Honor, on 5th I'm not available. I'm very sure I'm not available. If it's December, I prefer convenient date. We can get a date next week. Yes. Your Honor, I have a training which is starting tomorrow, so I cannot be available.
None of us is our application. This is an application, it's not an application of the state.
But it must be hard.
Sure, but this is an application, you cannot just come to the court. It's like 20 times the outbreak consulting that. You know that we are very
Those things have to be hard.
Your Honor, we can make this thing as seamless without dramatizing.
So, let us.
Yes, Your Honor.
I understand your practice hearings there, which will keep you here challenge, and then you also advance prosecution. Though the only duty is well staffed. Somebody standing for
Your Honor, I think let's not go into those legalities.
This is the prosecution of the case. Because for money,
You know, anything not fit is okay with me.
let them know we ask for anything. It's not this week.
No, I said I have a workshop that is starting tomorrow. We cannot dramatize this. It's part of my professional capacity.
Your Honor, we've been very, very patient with our project. On the first day of here, the caucus came, and he told us that he had a quick training to attend to him. And we did not object to it. We've been very accommodating. And we so wish that he offers that courteousness to this other side. That we've been very patient at all this. In any case, he has said he wants to make an application to quickly cross-examine the applicant. What is then that cause for the huge delay? Even when he intimated that he is dying to have the man rotting in prison to quickly come out. Therefore, it's self-defeating that he gives the prominence to a workshop for training, senior as he is, for three days, that he cannot carve out one day. When we've been here, Your Honor, we've been here on every single day, and even patiently waited, and given collegiality, and the seniority of some of us and him, we consider him as a senior, but collegiality. Let's consider either the 5th, and if he's not available, let him pick out one of the day within this week to say that he can come here and he has his applications honored in the view of justice. Please, we request you to urge our colleague, because we want to move in consensus.
training is part of the docket. That's the training. What is it? name of DPP, and this time is what the level of people is.
Your Honor, I can send someone. Your Honor, I can send someone, but in any case, I'm also always here. For example, next week I'm not available. But we are courteous enough to also delegate people on our side. So if that is easy to you, in any case, it's not his own responsibility that this case is up to him alone. There are very many people in the staff of the DPP. You can say therefore, I'll delegate another attorney. The other time he had a representative, and we accepted. So we have no problem with you, but delegate someone. Be a good servant of God.
Your Honor, I think my colleague is loud and clear. And in my good servanthood, Your Honor, I am not available this week. I request for a date when I am available, and I am here to handle this matter going forward. I am not I cannot delegate. I'm a delegate myself, a delegate of the DPP, and I am handling this matter for and on her behalf in personal conduct. So if the DPP has had me handle this matter, and the same DPP has given me training somewhere else, my brother, this man has been ill, he's not going to die in prison. I request for any other day other than this week. Otherwise, Your Honor,
from the third judge at that time, that judge is matter of December,
Also, that you
matter is that done after
also that you
after he has called our Welu Court. Yes. Okay. Interview was called our Welu Court. No.
የምትመለከቱት ሰይፉ በኢቢኤስ ነው። በያላችሁበት ጥሩ ጊዜ ነው የምንመኘው። ተወዳጅ ድምጻዊት ናት። ላለፉት በርካታ ዓመታት እንግዲህ በኢትዮጵያ ሙዚቃ ታሪክ የራሷን የሆነ አሻራ ኑራለች። ሞቅ አድርጌ ስጠራት እናንተ ራሳችሁ በጣም ደስ ይላችኋል። ከበርካታ ዓመታት በኋላ ነው ወደ ሚዲያ ብቅ የምትለው። አምሳል ምትኬ ሞቅ አድርጋችሁ ተቀበሉኝ። አምሳል ወደ መድረኩ። ሰላም ነው። በዓል መስለሽ ችርስ እንኳን ደህና መጣሽ ነው። አምሳል ምትኬ ካለች አንድ ፕሮግራም ላይ ይሞቃል። ደስ በቃ የራስሽ የሆነ ድባብ አለሽ። ደስ የሚል እሱ የሰጠሽ
እግዚአብሔር ይመስገን።
አዎ አሁን ራሱ ስትመጣ እኮ ሞቅ ብሏል አይደል? ለአምሳል
አመሰግናለሁ።
በሙዚቃ ህይወት ስንት ዓመት ሊባል ይችላል?
ከልጅነቴ ጀምሮ።
ከልጅነት?
አዎ።
ውልደቴ
ውልደቴ ጎንደር ነው።
ጎንደር የት?
ጎንደር ከተማ
እዛው። ጎንደር በጌምድር ነው የሚባለው አይደል?
በድሮ።
አዎ።
አሁን ጎንደር
ከተማው መሃል ፒያሳ እኮ የሚገርመው ጎንደር አለ፣ አዲስ አበባ አለ።
ፒያሳ ቀበሌ 13 ይባላል። እኔ ልዩ ስሙ ኤል ሼፕ ይባላል።
የስንት ዓመት ልጅ ሆና ነው ኤል ሼፕ? ሰፈሩ ራሱ ደስ ሲል
ኤል ሼፕ ይባላል።
ሙዚቀኛ ማለት አቀንቃኝ ሆንሽበትን አጋጣሚ ታስታውሻለሽ?
ወይ አላስታውሰው። ከልጅነት ጀምሮ ነው
መጀመሪያ የዘፈንሽው ዘፈን ታስታውሽ?
ወይ ያኔ በጣም ምን ስንቱን አስታውሰው። ወደኋላ ምክር ለመሰለሽ አሁን አምሳል እዚህ ውስጥ አለች ማለት አምሳል ወይኔ ቆንጆ ከማጋ ነው? ቤተሰባችን ናት። አልጋነሽ ትባላለች። ቤተሰባችን ናት።
አሁን እዚህ ላይ አምሳል ዘፋኝ ነበረች?
አይ አይደለችም።
እንደው ገና
ነኝ አባዮሽ ምናምን
ካለሽ አንቺ ነሽ የምታወጪው። ያኔ ድምጽ እንዳለሽ ይታወቅ ነበር?
ይሉኛል ቤተሰቦች። እንዴት ድምጽ አውቆ ይላሉ።
ሰፈር ውስጥ አንቺ ካለሽ ከፊት የምታወጪው አንቺ ነሽ።
አቀንቃኝ።
እስኪ እችስ አምሳል ነች? ምክንያቱም ፋይል አውጥቶ የሰጠኝ ሰው እነግርሻለሁ በኋላ ላይ እዛው ትነጋገራላችሁ።
እሺ ወይኔ ይሄም ጎንደር ነው።
እዚህ ላይ ምን እንደምታቀነቀኝ ታስታውሻለሽ?
ይሄ ያሰፉ አታለልከው ነው የዘፈንኩት።
ጸጉርሽ ባጭር ተቆርጧል፣ ጅንሱ ተለብሷል፣ ሽርብትን ደስ ይላል በጣም። ከዛ ቀበሌ ነው መጀመሪያ ወይስ ወረዳ?
ታዳጊ ህፃናት ታዳጊ ህፃናት ነበርኩ። ግን ከታዳጊ ህፃናት ኪነት ድምጼን ስለሚያምርና ስለሚወዱኝ ቀጥታ ከፍተኛ ኪነት ነበር የተመረጥኩት። አይቻልም ብሎ አንድ ቸርነት የሚባል የኛ የተመራጭ ነበር የወጣቶች። አንዴ በልጅነቷ እንዴት ወስዷታላችሁ አይሆንም ብሎ አስቀረኝ። እጠላው ነበር ለብዙ ጊዜ። እንዴት አልሄድም እዛ እነሱ ጋር ለምን አልሰራም ምናምን ብዬ።
እሱ ግን ጥሩ ነው ያደረገው።
እሱማ ልጅ ናት እንዴት ከፍተኛ ትሄዳለች ተብሎ ምናምን።
እዚህስ ጋር መዘነጡ እንዴት ነው? እኔ እኮ ግራ ገባኝ። የመጣልኝ ፋይል ትንሽ ለየት። ይሄ ያልበም አነሳስ ነው።
በጣም ዝንጥ ብዬ
ራሱ እንደዚህ
ቅጥነቴስ
ባይሆን እዚህ ጋር አቋቋምሽ ኤል ሼፕ